Good afternoon and welcome to this webinar. By way of introduction, my name is Greg Riegle, and I am privileged to be the managing partner of the Tysons, Virginia office of McGuireWoods. I'm also a member of the firm's real estate and land use practice. And lastly, like other presenters and panelists you're going to hear from, I'm actively involved in the firm's COVID-19 team. And we're delighted to have you participate in what we hope is a very topical and hopefully engaging topic as we go through the afternoon. In the way of a brief introduction to the law firm, I've put a slide up that gives you a snapshot of the depth and breadth of our legal expertise. And you see that the practice is national, geographically very diverse, and equally diverse in terms of the services. And I say that because we are finding consistently in the era of coronavirus and COVID-19 that the issues from a business or legal perspective increasingly are multidisciplinary. And the topic today is a perfect example of that dynamic in terms of something that at its heart raises a number of real estate and basic risk and liability consideration, but also touches on an equally wide range of business issues, employment issues, risk management issues, and data privacy issues, all of which fit very well and logically with the depth and breadth of our national sort of perspective. So we hope and think that we are uniquely positioned to give clients and friends good advice and good insight on these issues. And certainly as we go through the presentation today, you will hear more about our COVID-19 focus, and I would certainly commend your attention to the materials that are publicly available on our website. And with that, I'm going to thank you all again for joining us. I will gratefully pass the baton to my partner and colleague, Scott Adams, that will give you a more focused introduction to today's topic, the panelists, the format, and again, thank you for joining us today. Scott?
Thanks, Greg. And as Greg mentioned, I'm Scott Adams. I'm a land use and real estate partner based in McGuireWoods Tysons office, and also I lead the firm's land use practice group. And very excited for everyone to join today and welcome again for what we think is going to be a really great program. And we've got a great panel of McGuireWoods attorneys today to talk about some of the very timely issues related to premises liability and liability generally for businesses as we start to reopen. I think it's particularly timely for those of us in the DC region with many of the jurisdictions here planning to reopen starting tomorrow. And so as we start to see businesses reopen, it's vital for business owners and property owners to really be thinking about how to safely reopen, how to keep employees and visitors safe as a primary consideration, but also how to protect themselves from a legal standpoint. And as Greg mentioned, our team at McGuireWoods has been tracking litigation claims related to COVID-19 and advising clients on ways to safely reopen their businesses and their properties. And as we'll discuss, we'll discuss some of the claims that we've already seen that have been filed, and really what we expect to be an increase in those claims moving forward. And the panel will also talk about some of the best practices that we're seeing and considerations that all business owners and property owners should be taking. So very excited to introduce our panel today. As I mentioned, we've got a great group of McGuireWoods attorneys that are really at the forefront of these issues. Our first panelist is John Wilburn, who's a litigation partner based in Tysons. And John's practice has a concentration on real estate litigation. And as part of that concentration, John regularly litigates complex and challenging land use and development issues for a variety of clients, including private developers and owners, lenders, and also several municipalities and government entities. Our second panelist is Rick Holzheimer, and Rick is also a litigation partner based in Tysons. And Rick is a trial attorney with extensive courtroom experience who concentrates his litigation practice in construction, commercial litigation, government contracting, financial services, and real estate. Our third panelist is Drew Gann, who's a litigation associate based in our Richmond office. And Drew's practice focuses primarily on high-stakes product liability, environmental and mass tort litigation. And he's got significant experience with multi-district litigation matters and advising clients on punitive damages. Before we jump into the panel, I did want to cover a couple of housekeeping items. As we go through, if you have questions, you should be seeing a Q&A bar or entry box on your screen. Feel free to submit questions, and as we go through, we'll be monitoring that, and we'll do our best to respond to as many questions as we can during the presentation, then also at the end of the presentation, really trying to jump into those questions. And if for some reason we don't get to your question, we will be trying to follow up with everyone who submitted a question afterward to try and get you an answer. Also, just wanted to make sure everyone was aware that the slides that we're going to go through today, those are all going to be available to people who are participating, and those will be sent out to everyone after the webinar ends. So with that, I will turn it over to Drew Gann to really dive into the issue. Drew?
Thank you, Scott. As with any other major event, the COVID-19 pandemic has resulted in significant litigation. To date, more than 1,000 civil complaints have been filed related to the pandemic. And a review of these complaints show that plaintiffs are seeking refunds from schools, gyms, airlines, and other membership-based consumer services. They're suing financial institutions related to various government programs. They're suing employers based on employment status, and a whole host of other issues. But for the purposes of this discussion, I want to focus on a subset of these complaints, and these are lawsuits alleging personal injuries. And of these personal injury lawsuits, and as Scott mentioned, we have really seen two significant areas of filings. That is class actions and wrongful death.
Drew, I think that's a great starting point, and obviously there's a lot of other litigation that kind of spins off those class actions, wrongful death, premises liability. For example, one of the areas we expect to see a lot of additional litigation is in the area of insurance. Insurance claims whenever there's any sort of personal injury or injury based on the premises of a business leads to insurance claims. And we'll talk about it a little bit more later. But in addition to the class action wrongful deaths, we see other topics such as insurance. There's going to be employment issues and others like that, including, as was discussed earlier, we expect to see some privacy issues, maybe even some healthcare issues. So we'll touch on those as well, but obviously we're focusing on kind of premises liability and ones that are related to that.
Yeah, and digging into these personal injury claims, we see that they seem to have the same core allegation, and that is the defendant knew or should have known the dangers of COVID-19 but failed to act reasonably. And to support this core allegation, plaintiffs have used a whole array of supporting allegations, and we have went through and kind of reviewed these complaints and come up with the top 10 supporting allegations. And just to walk through them, the first one is the defendant failed to follow governmental regulations or recommendations, including OSHA and the CDC. The defendant failed to provide sufficient personal protective equipment, PPE. The defendant failed to implement and enforce social distancing policies. The defendant failed to properly train personnel to follow procedures designed to minimize the risk of contracting the virus. And the defendant failed to provide sufficient opportunities to wash hands or provide adequate antibacterial soaps, wipes, and other cleaning agents, and that's both for employees and visitors or invitees to the premise.
And Drew, before we get on to the next page, and these are just some top 10 allegations, a lot of ones, Drew's done an exhaustive search, a lot of these complaints, and we're seeing these. And this is not meant to be exhaustive, but, plaintiffs and personal injury lawyers and people who are injured in general are going to be very creative. So we do expect to see a lot of other issues.
Yeah, let me add one of the challenges, I think, for those either bringing the claims or more importantly to this group defending the claims is understanding what I'd say is the evolving standard of care. And for any personal injury case, it really starts with, the plaintiff has to establish what the standard of care is, and that standard of care was breached and injury resulted therefrom. And when you look at these supporting allegations, one of the things that jumps out to me is that we're dealing with concepts that have changed dramatically, at least in my mind, over the last few months. For example, number one, defendant failed to follow governmental regulations or recommendations, including but not limited to OSHA and CDC. we all probably recall that things like masks, whether a mask is recommended or not, has changed dramatically in just 6 weeks. If you go back to 6.5 weeks ago, the CDC was advising against the use of masks for personal protective equipment for anyone but healthcare workers. And the guidance from the Surgeon General and the CDC was that it was actually counterproductive to our safety because people tended to use them incorrectly or to touch their faces. There were a series of reasons given why. Now we have very opposite guidance and direction from not only the CDC but all our local officials and governors to use masks. And in some some stores such as Costco and Walmart, it's a requirement. And in some jurisdictions like Los Angeles County, it's a requirement even to wear a mask when you go outside. And so the point that I think this makes as to a premises liability or a personal injury type claim is litigating what the standard of care was at any particular point in time is going to be critical, or understanding what it was at any particular point in time is going to be critical in defending a claim. So if somebody claims they contracted COVID-19 in the middle of May 2020, and it's because they were allowed to go into a dollar store where people weren't required to wear masks and the standard of care is to wear a mask, that's very different than the standard of care that may have existed 6 weeks ago, a claim in the middle of March. And so when you're defending these claims or looking at what your obligations are, it's going to be critically important that property owners document and keep track of what the recommendations are at any particular period of time. That record can be recreated. But more importantly, what impositions, what you are requiring of your employees, your tenants, your invitees at any particular period of time. And I think, sort of jumping ahead a little bit, I think it's going to be challenging for the plaintiff's bar to be successful in many of these claims because this virus is, by definition, a novel virus. And these recommendations from OSHA and CDC and our local government bodies have changed so much in such a short period of time. I think it's going to be difficult for them to establish that there was either a local or a national standard of care that was so well known and so well settled that violation of it, would support a tort claim. And some of these others, top 10 supporting allegations, you can see some of these other examples, in my mind, are examples of activities or recommendations that have changed in a matter of weeks and months. And generally speaking, that sort of shifting sand approach to policy is inadequate to set a standard of care. Mm-hmm. Anyway, Drew, I didn't mean to cut you off there, but I wanted to talk about, I think, that element of, how the standard of care has changed dramatically during the course of this. I'm not even sure we have a set standard of care through today, although you want to follow whatever the latest guidance is from the CDC. That provides some safe harbor.
No, that was great. And as you will see, as I read through the others, they get more and more, there's the evolution of these claims. So 6 is just the defendant failed to encourage those who are believed to be sick to stay at home or failed to prohibit people who were exhibiting symptoms from entering premises. 7, they failed to implement testing protocols. 8, they failed to implement or conduct periodic inspections of cleaning protocols. And then 9 is a allegation that we're seeing more and more of recently, and this kind of shows the evolution of these claims where a defendant failed to implement engineering controls, including but not limited to high-efficiency air filters, ventilation rates, and physical barriers. And then 10 is kind of another fallback. A lot of people could actually consider this another core allegation. Just at the end of the day, plaintiffs are just throwing out, at the end, the defendant failed to properly warn of the dangers. So those are the top 10.
Yeah, Drew, thanks. And kind of building off that and kind of those tough allegations and kind of, what can we glean from this? And we'll get to this a little more later. But, failure to warn and failure to implement, one issue that's coming up is, do you assume that people know what's going on? Obviously, there's an obligation on the business owner to stay up to date as to what the CDC recommendations are and the state, federal, and local recommendations are. But what does that mean? What do you do with that information? Well, one of the things, and we'll get to later, is make sure that the employees know of it. So while the business owner is able to kind of keep track of that, what are they doing to disseminate that information as to what the latest practices are to their employees, and is that being documented? John talked about the evolving standard of care and how it's changing over time. Well, as a business owner or as a business, as you deal with, multiple stores, what sort of information and directives are being given to those stores and the employees within those stores as what they should be doing? Businesses can't assume that their employees know. They have to be documenting that they are keeping their employees and businesses up to date on the latest evolving standard of care, and at the same time are taking steps. So another thing to talk about notice. When people are coming in, obviously you don't want to have a long placard out front providing information as to the coronavirus and what people should be doing, but at the same time, a business can't assume that somebody who's walking through the front door understands what appropriate procedures are supposed to be or what they should be doing in this pandemic. It's hard to not turn on the news and get it, but it would be a business shouldn't assume that somebody coming in is fully informed of these issues and should do what they can to inform people as to what they should be doing once they come into the store. All right, sorry, back to you, Drew.
No, thank you. And so, so those are the top 10 supporting allegations. So we've kind of talked about what cases have been filed, what are they saying. So moving forward to kind of like what are the general legal principles that we are going to be working with here. Really, these personal injury lawsuits can be divided into two buckets where two legal principles are really at issue. First are the personal injury claims brought by the employees themselves, which could be governed by the principles of workers' compensation law, which we'll discuss a little bit later. And then the second are claims brought by customers and non-employees, and these will largely be based on general premises liability principles that usually require a showing of negligence on behalf of the defendant. And going into the idea of negligence, while state laws vary and kind of going back to what is reasonable in one state may not be reasonable in another, the linchpin is reasonableness. So the defendant must act reasonable. And there will be several factors that courts seem to be willing to consider and that we will see courts consider in the pandemic litigation, compliance with federal, state, and local guidelines, and the comparison of actions of competitors and other entities. These will be used to establish a baseline which may not even have been established yet, as they said, because this could be an ever-evolving baseline that's obviously always changing.
Well, and as Drew talked about, kind of varying among state law, obviously, companies that have businesses located throughout the United States are going to have to look at kind of what each state-by-state negligence law is going to be. Even locally, to the extent you're in the D.C. area or Northern Virginia, Maryland area, here you have three jurisdictions that are right next to each other. So even though businesses may not have across the country, even if you're in one geographic area like the D.C. area, you're going to have to understand that each of the states and jurisdictions are going to have different laws. For example, some states have comparative negligence law, which any damages or any claims for negligence are based upon percentage amount of negligence for each party. If a business is 75% at negligent and the plaintiff is 25% at negligent, at that point, any award is going to be divided up based upon the comparative negligence, versus other jurisdictions such as Virginia, D.C., and other areas like that use contributory negligence, where to the extent a business is at fault, that fault can be counterbalanced if the plaintiff has any contributory negligence, which could be a bar. So it's easy to kind of get overwhelmed with all the various states and jurisdictions, but this is a state-by-state analysis because negligence standards vary by jurisdiction. And as Drew talked about, the linchpin is reasonableness. It's hard to say, especially with something like a novel virus, what is the standard of care? Or as John said, it's an evolving standard of care. It's one based upon information that we have at the time. But Drew used the word linchpin, and I think that's very appropriate because the key at the end of the day, the people who are deciding these issues are usually juries. A judge can be involved, or it could be a bench trial. But at the end of the day, what a standard of care means is what should you be doing? And the standard of care is usually based upon what's reasonable for that business, whether it's a standard of care for a doctor or a standard of care for a business or some sort of company. The ultimate issue is going to be, were they doing and acting reasonable based upon all the information that was available at the time, based upon all of the tools that they had? So, you know, while it's hard to say what a specific person or company should be doing in a specific situation, just in the back of the mind of any business as they're creating their policies is what is reasonable. And while people may disagree as to what's reasonable, you know, the linchpin is reasonableness, and that's something that should be considered.
And I agree. And another thing that I think that we can guarantee is that plaintiffs' attorneys will focus really on two things in a lot of these cases. One is they'll focus on the most restrictive policies available, whether that's from a neighboring state, a neighboring locality, even a state all the way across the United States. They will find policies from other places and argue that you, defendant, did not do that, therefore you weren't reasonable. And second, similarly, these alleged failures of the defendant will be the crutch of their case. So therefore, it's important to stay on top of the changing circumstances and strive to maintain the best, most up-to-date policies to ensure the safety of anyone that comes into the premise. And so that was lawsuits by people that come onto your premise, non-employees. Now turning to personal injury claims by employees, the first line of defense will be the workers' compensation exclusivity. And once again, workers' compensation laws vary state by state. But if applicable, workers' comp exclusivity would shield the employer from tort claims brought by employees. And while many different issues can arise in arguing workers' compensation exclusivity, there's really two important issues. First is, does COVID-19 qualify as a workplace injury or occupational disease under workers' compensation? And some states' workers' compensation schemes apply broadly to any work-related injuries. And in those states, it's likely that the contraction of COVID-19 will likely count as a work-related injury, and any tort claim will be barred. In other states, however, workplace injuries or occupational diseases are defined more narrowly, and they've even excluded diseases that an employee could have been exposed to outside of their employment. Specifically, some states exclude ordinary diseases of life, and courts have interpreted that to mean flu, such as the flu, and those are particularly excluded from some states' workers' compensation schemes. And so in those states, employers will have to litigate whether COVID-19 exposure qualifies as a workplace injury or whether it will be excluded. And then the second key issue is whether any exceptions apply. And the big exception that will probably come to the forefront is the intentional tort exception. Most states do have an intentional tort exception. However, they are divided on what is required to establish that exception. And this division generally falls into two camps. For the exception to apply, some states require showing that the employers intended the harm suffered by their employees, and these can be referred to as the actual intent state. For this case, the intentional tort exception will almost certainly not apply because no employer intended to cause harm. So that one's going to be a hard burden for the plaintiff to prove. But there is a second camp of states which uses this exception and requires only a showing that employers expose their employees to a condition despite substantial certainty that the condition will result in a harm. And 11 states apply this version of the substantial certainty rule, and this rule generally provides that an employer is liable in tort where there's a substantial certainty that the employee's injuries will be the outcome of the employer's conduct. So that's certainly a fact question that's going to have a lot of litigation around it as we move forward, and we are seeing some some employee tort claims and some workers' compensation defenses being raised as we speak.
Drew, I want to add one point under the negligence slide. I think it was slide 11. And we identified that, where the plaintiff's bar will look to establish a standard of care, and a couple of those sources will be one, existing federal, state, and local guidelines. That'll be obviously, I think, the most fertile area. The second will be comparison to other competitors. But there's a third one that I think it's sort of a practice tip that you should keep in mind, and that is plaintiff's lawyers will always want to look to your internal policies and procedures. And there's a split in the law on whether and to what extent internal policies and procedures are admissible or usable to establish a standard of care. But you need to be very mindful that if you have now or you in the future adopt internal policies and procedures to address the COVID situation or other similar health-related circumstances, that in any litigation, the plaintiff's going to first look to your policies. And it's pretty powerful, I think, examination when they can use it to say that you recognize that there was this danger, COVID-19 or something else, and in response to that, you drafted and promulgated and told your employees to adopt a certain set of policies and procedures to mitigate that risk or to avoid that risk to your employees and your invitees. And then, just hypothetically, let's say there's 10 steps, that include cleaning protocols, some sort of contact tracing, masks, social distancing, all the types of things that we're talking about generally. But if you put things in your policies and procedures, what the plaintiffs will want to do is walk through each of those and ask, whether and to what extent you complied with them. And hopefully, from their perspective, hold up your internal policies and procedures and compare that to what's actually being done at the premises, and then argue to the court or to a jury that any deviation from those policies and procedures is a breach of the standard of care. As I mentioned, many states recognize that your internal policies and procedures can exceed the standard of care. You can choose to do more than's required, and so failing to do that may not constitute a claim, but it is powerful evidence if they can use it. So we've seen too often where a client will see a circumstance like we face now, and people are quick to adopt new standards and operating procedures to address it. I think that's great, but the follow-through on it is equally, if not more important, that if you do set up those requirements, that you have somebody in the organization whose responsibility it is to follow up and monitor and ensure that those internal operations that you've adopted are followed, and importantly, that you document that you followed those. That could be very important later. So when you're thinking about, what you need to comply with, obviously federal, state, local guidelines, be aware of what the industry is doing. You don't want to be an outlier. If everybody in your particular industry is requiring masks as a condition of entry onto the property, or they're doing temperature checks, for employees as a condition of operating, it doesn't necessarily, set a standard of care, but you should be aware that if that becomes the norm, it'll be used against you. And then the third one that I was adding to the slide is your own internal policies and procedures. Make sure that, if you adopt those, that they're at least consistent with whatever the national guidance and the local requirements are on it. And then equally importantly, make sure they're followed and that following it is documented. One of the worst things you can do is create policies to address a significant issue like this and then not follow it.
Yeah, and as Josh said, just to build off that, to the extent, you do set a policy, you need to follow it. Yeah, that's going to be important, especially we've seen a lot of businesses who say, well, we've increased cleanings, or we have, twice a day cleanings, or all touch points are sterilized and sanitized, X number of times per day. And, that looks like a great policy and procedure, and is one that I think will give a lot of people comfort. But to the extent that they're not being followed, that is going to set up an issue, whether it's brought up with the, it's raising the standard of care or causing an issue there, or it might lead into claims that, there's false advertising, or claims that, yes, you're doing this to entice people to come in, but turns out, none of the touch points are sanitized throughout the day. You just did that to entice people to come in, make them feel that your business was safe. by having these great policies and procedures, but they weren't being followed. So another point to build off that is, have a realistic policy and make sure it's enforced, and make sure that people know it needs to be enforced. It's not just something that's being said to make people feel comfortable, and know that the employees, so they may get questioned. Yeah, how often do you guys clean here? Or what are you guys doing to help protect against the coronavirus? The people who are dealing with the customers, people who are dealing with the public need to know what's being done, and it need to be following it.
So let me just add it real quick. When we're saying this to you, I'm not intending to suggest that any of these things actually set either a local or a national standard of care. I think the fact that we're talking about, I think Rick or I or Drew used the phrase, shifting standard of care or evolving standard of care, reveals that there may not be. I mean, there's always some minimum level of protection you have to offer your employees and your invitees, but this has been such a novel circumstance with so many confusing and differing sets of guidance and facts coming out, that I think that those business owners or property owners that unfortunately have to defend against these premises liability claims, I think they're going to have a wealth of strong defenses available to them, because they're just, I don't think that there is a set standard of care. Maybe we're evolving into one now, but over the last few months, so many different viewpoints on it, that I think that's going to be a strong point of defense. The other one we'll talk about, we'll probably get to it, I may be jumping ahead here, is the concept of causation. And it really ties into this issue. It was unclear for a long period of time what the best processes were to stop the spread of this disease. At one point, the guidance from CDC is that contact surfaces held the virus live and communicable for 14 days. And they reversed that position a few days ago. And I mentioned the issue of masks. But the issue of causation, even if you can prove that there's an existing standard of care and you can show that somebody, caught this terrible disease, the burden is on the plaintiff to show that they caught the disease because of that breach in the standard of care. And in the environment that we are in right now, it's going to be very hard, I think, to trace that to particular incidents at businesses. It's not impossible. There's a case out of Texas where a business was open and an employee was allowed to work in a salon who was sick. They didn't know that she obviously had COVID, and they've traced 84 occurrences to that particular person. That's an example where if you have, sufficient, contact tracing data available to you, they can trace it back to a particular location. There are a few examples of that, but I think it's I think there's fertile ground for a defense attorney resisting one of these claims to examine a plaintiff and find out all of the people with whom they were in contact or the places they were, and all of those might be exposure points. And I don't want to jump ahead on too much on causation, but I did want to make the point that I think there are strong defenses to these claims that exist for people that have suffered injuries probably through this point. Exceptions to that would be, your cruise lines where you've got a closed environment and it's fairly easy to show, what the cause of the infection was. But most of us aren't on cruises and aren't in closed environments, and I think it's going to be more difficult for plaintiffs' attorneys to make that tracing and establish the causation element.
I did want to touch on a point that you brought up about internal policies, and one thing that I'm seeing that's unique about this pandemic is a lot of companies have decided to put some of their policies that would be internal and wouldn't be available to the public online about what they're doing to clean the premises and to keep their customers and workers safe. And we have seen cases, especially more recently, using those policies against them. They won't even mention the federal, state, or local guidelines or actions of competitors. They'll do exactly as you said. They'll just say, you're not even standing up to your own policy. Your policy says X, and we went on to the premise, and X was not happening. So I think that was a good point for what courts will have to consider.
Internal policies, I find, are like contracts. When people draft them, they're usually wonderful, and then oftentimes they go into a drawer and aren't examined again until there's litigation, and then you start pouring through all of those requirements that you've imposed on yourself. And there's good reason to impose those requirements on yourself, via contract or policy, but it's the execution and the follow-through on them that's really important, and it's going to be critically so, I think, going forward in defending against these claims. Because, while plaintiffs' lawyers may struggle to find a national or local standard of care that's actionable for them, if they can get their hands on, cleaning protocols or, health check protocols at your business and find someone who will testify that you just didn't follow them, that's powerful evidence that would be harmful to your defense.
Yeah, no, that is exactly what we're seeing. So we've talked about the employees, and we've talked about non-employees. There's been a third category which fit in the non-employees that we've been seeing more recently, and this is kind of what you were talking about with the tracing. These are cases filed alleging that an employee had infected another individual, and it could be it's usually a family member, but it could be someone that they serviced or that they came in contact while they were working. And this is an interesting area that's going to have a lot of litigation, and the employer's liability will seem to turn on whether there's an existence or non-existence of a duty. And using the asbestos world as an example, it looks like the courts will consider numerous factors, and here's 5 for just an example. The relationship between the parties, i.e. the employer and the person that was infected, the social utility of the actor's conduct, the nature of risk imposed and foreseeability of the harm incurred, the consequences of imposing a duty upon the actor, i.e. the employer, and the overall public interest in the proposed solution. So these, we haven't seen a lot of cases on this recently, but they are popping up a little bit more, and as things start opening up, we expect that more is going to be coming down the pipeline probably very soon.
Yeah, before we move off of policies, there was a question on policies specifically, and the question is, what do you see as the impact of adopting different internal policies based on local requirements? Does the strictest state requirement set the standard of care? And that's a great question because you will see that you sometimes have differing standards depending on which governmental body is issuing them. We've got guidance from the CDC and the federal government, and then Virginia, using Virginia as an example, has its own guidance that the governor's office has issued, but we're also getting even more strict guidance coming out of some of our localities, particularly in Northern Virginia. It's why you have this divergence in Virginia where the majority of Virginia is open. The northern communities are not, although we are in part beginning tomorrow. So the question is, which of those provide the standard of care? And unfortunately, there's not a case that has addressed that in this context yet. The safest thing is we're obviously obligated to abide by, if there is a federal law on it or a state law that dictates a certain level of protection, that you've got to follow that. But you may have, lesser requirements at the local level or more significant requirements at the local level. You should follow the most strict guidance that you have, and that'll protect you from a claim either from the county level or the state level or the federal level. That's my sense of that. Drew, based on what you've seen, how would you answer that question?
No, I think that's right, and I think you kind of need to take it case by case and determine what's best for the situation and best for the company at issue. And unfortunately, we're seeing some localities in some states, and not really the national guides, but they could kind of butt heads sometimes. And so sometimes you may have to impose different requirements in different areas. But if you can impose the strictest requirement, once again, they could use that policy against you in a state or a locality where it's not required to say that you didn't even comply with your own standard, although the locality itself did not set that standard.
Right. I mean, an example would be, and Greg or Scott may speak to this, one of the things we're wrestling with in Northern Virginia on reopening is, restaurants. And, we're going to allow outdoor seating, but at limited capacity. And so, and Greg or Scott, is it 50% that we're looking at for outdoor seating?
We are, yeah. Yep. Yeah, we're looking at 50% right now.
Right. And so that's not a national requirement. It's really a local requirement. And you wonder how that plays out. I've spoken to a couple of clients one in particular, and they own a restaurant that has a certain level of seating, and the question was, we normally have six tables for outdoor seating because it's not much of what we do. Can we put 12 out there and still maintain our 6, or is the idea that we can only have 3? And it's such a novel issue, and those are the types of operational questions that clients have that you're not going to find at a CDC guidance or at a state level, but maybe on the local level where you deal directly with the commissioners. And so I think it's critical to obviously comply with. Go ahead, Scott.
I was just going to say, just to follow up on that, I mean, it truly is hyper localized. You have to look at the specific jurisdiction that you're in. For example, Fairfax County here in Virginia is passing an ordinance later today on restaurant reopening that has pretty flexible standards for how those spaces can be configured and the type of permitting you need to go through. Whereas in Arlington, Alexandria, they have a permit process set up before you can start to make those changes. So it really is something where, depending on the locality that your restaurant is located, you need to be checking, what type of regulations they put in place for expanding out those outdoor seating areas.
And you can imagine the challenge if you're a client with a national footprint. So you've got different requirements, according to different states, different tort laws in different states, and then even on the local level, municipalities and counties may have their own impositions. And so it's hard, it's obviously hard for a small business. It's hard for a large business with a large footprint because there really isn't, I think, a one size answer that fits all of your operations because these things aren't necessarily local. It's a little bit off topic. I know we're talking about questions at the end, but there was one that I wanted to pick up here, and this is a question about bringing employees. And one of the ideas that employers have is to have their employees come in and sign a waiver. You're going to waive any liability associated with getting sick from COVID if you come back to work. And we had a question on that. Is that effective in the same way that if I went horseback riding and I'd sign a waiver? The answer, unfortunately, is it depends on the jurisdiction. Many jurisdictions, like Virginia, waivers that waive tort damages in advance are void as against public policy. So in the horse riding example, I can sign a waiver, but if I go out and ride the horse and the saddle is negligently put on the horse, or there's some other negligence by the horse farm, that waiver is not valid, and I can sue on it because it's void as against public policy. So that's the law in Virginia. The reason that you still see waivers like that in Virginia and other places is because there's a chilling effect. So there's studies that show that people that sign waivers, even if the waivers are void, oftentimes don't bring lawsuits. So there's a reason that businesses still have people sign waivers in those jurisdictions where pre-negligence waivers are void as against public policy. In the context of COVID, I think it's going to be jurisdictionally specific whether you can do that. But even there, if you're deemed grossly negligent, the waiver's likely going to be invalid. And go ahead, Rick.
Well, I was going to say, and I think we've seen in the news recently that Disney was reopening, and one of the things they were talking about doing to address this was to have waivers as people come in to go to Disney World. Whether or not that's void against public policy in Florida is an issue, but as John said, can have a chilling effect, which may be one reason that a lot of companies seem to be doing that.
Yeah, and I'm going to get back on track, Drew, to your presentation, but one other thing that I wanted to touch on, and again, standard of care before we move completely off of it, is this idea of, what expense do you have to undertake? And, the standard of care, what a plaintiff's lawyer would have you do when he sues you is put you in a room, you're under oath, you're being deposed, and he would go through all of the theoretical engineering and other things you could have undertaken to avoid this. And as you know, engineering modifications to your premises cost money. And there's a law firm, I've talked to one of the partners there, and what they were looking at as they reopen is a couple of things. They're going to do facial recognition, they're going to do remote temperature check of employees, and they actually were pricing out this UV device, and I don't know the science behind it, some of you may, But as you walk in the lobby, you actually would walk through this device that would bathe you in some form of ultraviolet light that has some sort of beneficial effect in terms of killing viruses. And they're not going to go with that because it's very expensive. But I guess my point, and what this goes to in terms of standard of care, is when you're evaluating reopening and how to protect your employees and your invitees, there's always a mind towards the cost of doing that. And if you end up litigating one of these cases, be aware that the plaintiff's attorneys will try and have you monetize what the cost would have been to do those things. Facial recognition, remote temperature checks, UV lighting, installing plastic face shields, putting a nurse on staff to check people's health periodically, third-party monitoring of your cleaning and disinfecting, all of those things that you could do, and then try and have you acknowledge that the reason you didn't do it is because of X. And it's a really damaging thing to have somebody be able to put up in front of a jury that you avoided these health and safety protocols because of the bottom line. And I just think be aware of those things. You don't need to go to extraordinary financial extremes in order to make your premises completely, free of all possible viruses. But be aware that cost benefit, that cost safety balance is something that will be explored by the plaintiff's attorneys in any litigation.
Yeah, and building off what John said, that ties right into the reasonableness thing that we talked about earlier, which is when deciding how to deal with this issue, do you need to have this giant UV bathing system before people enter into that costs, a lot of money. Reasonableness is the standard that comes in versus, you walked into stores and they have lines on the floor to show 6 feet apart. So when people are standing in line, they know how far. How much does that cost, for a little piece of blue tape with some signage on the floor. So, obviously the more expensive it is, the less reasonable it is. The cheaper it is to do something such as putting lines on the floor, or giving directions, or putting a note on the front that tells people what to do. Those are inexpensive, so those are more likely to be something that should be done. Okay.
Yeah, and I did want to touch real quick back on the waiver, just real quick, kind of this whole idea. I know some places, although it's void against public policy, some people are still considering using waivers or some other signed thing just to counteract the failure to warn claim that we see keep coming up, because they will say in the waiver, while we are doing X, Y, and Z, we cannot guarantee that we have eliminated all strands of the virus on our premise. So that's obviously a consideration for those waivers. But once again, state law varies on how exactly strong of a defense that is.
Yeah, Drew, I think that's a great point because, people signing these things, one, is it a waiver or is it not a waiver? Two, is it an informed consent? You're walking into this facility, you're walking into this business or this office, please understand that we're doing the best we can. We have, 4 hours cleanups and we're spraying with disinfectants. And letting people know this is what we're doing. Obviously, we can't guarantee anything. And so in those situations, it may not be so much a waiver as it is kind of informed consent, that people understand what they're getting into. I think that's a great point, Drew.
And I think our next thing was just talking about some of the evidentiary issues that we've already touched on, at least somewhat. Yeah.
And looking through that, we wanted to pull some issues together here for you. We've obviously talked about causation a lot. Causation would be ultimately, can the plaintiff prove that they've caught the disease or they had some damage or illness directly related to a business's failure to meet the standard of care? And I think we've talked about that a lot in here. And so just want to put something together here for there. We've talked about the standard of care and noted how it was evolving. So there's not a national standard of care. It's going to be, depending on your state and local jurisdiction. But most importantly, as John noted, depending on the time, because what we knew 6 weeks ago is different than what we know now. And frankly, will be something different than we know 6 weeks from now. So trying to stay current on the standard of care, staying current on the recommendations is going to be important because it is evolving, and you can't just stop at one point in time and saying, listen, what, I've tried to do it, I've done the best, and, they may change it, I don't care. No, it's an evolving standard of care, and businesses need to evolve as well. Dealing with customer relations, I think Drew touched on it, talking about the informed consent. A lot of this is getting and dealing with the customers. What are customers being told? What are businesses do to meet what they promise to the customers? And what are the employees being told? It's important to make sure that everyone is fully informed of the situation as they walk through the front door. Don't assume that people know what they should be doing. We all seem to understand now that it should be 6 feet apart, but somebody who walks in through that front door of a business or maybe using the services of that business can't assume that they know that. And whether that's based on signage, marks on the floor, and informed consent, there needs to be some reach out to identify to the customers what they should be doing when they enter into a particular establishment. And lastly, on the evidentiary issues, we've talked about effectiveness of waivers. Again, that's going to depend on this particular jurisdiction. In many places, it's void against policy. You can't waive negligence in advance. But as John has said, sometimes these are done, they have a chilling effect on litigation. Sometimes it's viewed as an informed consent. So, while something should not necessarily be a waiver in a particular state, there can be other reasons to have people sign a consent.
One of the things I want to add, go ahead, Drew.
No, go ahead.
Well, one of the sort of worries that I have on these evidentiary issues is I think you have some competing considerations. On the one hand, as a law firm, we would always tell you want to document everything, and I think that's true. You want to be really careful that you document if there is a complaint or if somebody comes and tells you that a coworker or a worker is sick, that you've documented that, you've taken appropriate actions that you also record. The thing that you need to be mindful of, and this is I'm telling Scott and Greg, maybe it's an issue for another presentation, but is privacy issues, either data privacy and HIPAA related issues, and we've got this very strange occurrence here where we were trying to protect against the protect the employees, protect the business invitees, and one of the ways that we're learning that we would need to do that is to understand the health of the people that are on our premises. And obviously it's more difficult to do with invitees. Disney World's got some ideas on how they'll do that, including temperature checks. Our businesses will be temperature checks and health checks of employees. And so I think that you need to be really mindful, and it's, in talking to employment lawyers about how you handle that information, to whom you share it, and what you do with it. Because while it's, critical to make sure you protect your premises against, the spread of this disease, you don't want to buy other types of claims, either HIPAA violations or employment discrimination claims, because people either overreact to, a person's perceived health, or they share health related information to people to whom, they're not entitled to share it. So that's something I would just be really, really careful about, because, defending against the COVID type claims may lead you into employment or data privacy issues if you're not mindful of how you're handling that information. One of the questions, I'll sort of jump in here, dealt with workers' comp, and it's a great question. It's focused on Virginia. Do we have a sense how or where Virginia will come down on COVID-19 in regards to workers' comp being a workplace injury or not? And, I don't know that we know the answer to that yet. We've been tracking that and trying to get some guidance. I think that it sort of falls into two buckets. There's a statute that's specific to healthcare providers. And so if we're talking about somebody who got sick at Fairfax Hospital or Loudoun Hospital, there's a statute that covers that. And those types of claims are likely to be compensable. The challenge, I think, is going to be, for someone else. Let's say I get COVID-19 and I want to bring a workers' comp claim associated with my employment here at McGuireWoods. There is, did I get it? Can I establish I got it at McGuireWoods, or is this a disease that is one that's referred to as an ordinary disease of life? That's the classification under the workers' comp rules in Virginia. And, things like, typically like the flu or other diseases are called, ordinary disease of life, and they're typically not compensable under workers' comp. And it seems to me that this may fall into that category, but obviously this is a bit different, and there's a lot of focus on it. And so if we were to have a reported case, hypothetically, of, COVID at one of our offices and an outbreak there, and somebody with employees, I think there might be good grounds to bring that that workers' comp claim, but there really isn't any clear guidance yet out of Virginia on it. I think historically we'd fall under the ordinary disease of life classification, and I just don't think we've got a ruling that would move it beyond that, at least right now. But you do have examples, and there's a client that I can think of right now, and they had an outbreak of 26 people at their place of employment that had with COVID, and that's obviously a strong case to show that it was work related or premises, work premises related. But just your one-off person making a claim because they had COVID, I think that's going to be a tough fight for them unless there's some change in guidance out of Virginia workers' comp.
Hey, John, and while we're talking about workers' comp, there's a second question that we got related to that, asking whether it's better for someone's workers' compensation carrier to find that it was work-related, even if there are no damages.
Yeah, I saw that. I'm not sure. I think it's a really interesting question. I don't know whether, it really depends on whose perspective it's from. So if you're the workers' comp carrier, you probably want to find it's not covered. But even if, I guess the upside, if you're the employer or the premises, the employer is you'd rather it be workers' comp related than have them bring some other type of claim against you. But if there are no damages, and that's what the question presupposes, then I'm not sure it'll matter too much, but I would think if I'm workers' comp carrier, I would want it not to be a workers' comp claim, because I think that does create a little bit of a shift in your liability exposure from the carrier's perspective. If COVID is now a covered incident for workers' comp, that one may be no damage, but the next 4 may have damages. So I'd probably, again, if I were representing the workers' comp carrier, I'd want there to be no findings that COVID was a compensable event under workers' comp coverage. I'm just cycling through some of the questions, and I did want to talk about one of the issues I think I don't want to say moot these issues, this presentation, it doesn't, but I think everybody should have on their radar what's happening in Congress in terms of tort protection from these claims. And there was a hearing, a Senate hearing, gosh, I think it was May 12th. It was May 12th, I think, about exactly this issue. We want to reopen the country, we want to reopen the economy, but business owners are understandably very concerned about exposure to lawsuits. As Drew mentioned, we're over 1,000 lawsuits already, and this pandemic is relatively new to us. And so the Senate, at least, is they've either drafted, I know as of the 12th, they had in draft form a proposal that would give limited, at that point, immunity to business owners for COVID. I don't know whether it has a chance of passing or not. The president has made statements in support of it. The U.S. Chamber of Commerce testified at that hearing. They had a representative testify as to why it was important. It would be crippling to many businesses to have to face, the number of lawsuits that are likely to come out of this. They had folks from the insurance industry that testified in favor of it. But then, of course, you have countervailing thoughts from the plaintiffs' bar and their representatives, and their view is that if we make businesses immune from premises liability, the liability associated with COVID, then they lack the incentive to take the steps necessary to protect the public health. So that's the stated reason for the opposition to such immunity. The real reason is money. But I think my sense is that there's good reason to include some form of business protection in the next or in one of these rounds of COVID, one of these COVID relief bills, and that's the goal, at least of some members of the House and Senate. We'll see if it happens, but I think personally that's very important to reopening the country with some sense of security that people can operate without the risk of being sued into oblivion.
Yeah,
and since you brought that up too, it's probably timely to note that we do have a very active federal practice associated with our affiliate McGuireWoods Consulting, and they put out what amounts to a daily update on legislative initiatives, both at the federal level and across the states. And if you go to our website, you can sign up to get those alerts, and it particularly sort of dovetailing off the variances that occur across the different states and localities. That's a good one-stop place to stay up on that sort of information as it evolves, which it will undoubtedly evolve, and it just highlights the intersecting topics. I'll also note that we will be doing the follow-on event with respect to data privacy issues you touched on and the associated labor and employment. Again, just the inevitable intersections. So I just wanted to make that point for the broader cause. It's on with the show, right?
Yeah, on with the show. And also to end on a high point. It's weird to say a high point, but when we're looking at solutions for this situation that we're in, a tough one, whether it's legislation or being preventative. Another aspect, and just want to touch briefly on, is insurance. And it is easy for a lot of businesses to say, well, I didn't see anything in my insurance policy covering pandemics or issues like that, or there's definitely not something in there. I think a close read or reaching out to your insurance contact or your insurance agent is probably worth doing, because there's a lot of provisions, and we've seen litigation starting up on insurance provisions as to business coverage. There's a lot of extensions. So in addition to the general policy, there might be some specific extensions for business interruption or law enforcement or civil interruption, where if your business is shut down for some law enforcement reasons, such as for these pandemics, there can be some business interruption insurance. There's issues that are coming up in these insurance litigations, such as, well, usually it's because there's a fire, so the business is interrupted because there was a fire and requires damage to the property. But we're starting to see the beginnings of kind of an insurance litigation wave, which is, okay, well, is a virus that is on the premises and covering the merchandise, is that a damage to the property? Because it's something that if people touch it, they're going to be damaged and they could be sickened by. So we're seeing issues on business interruption coverage, law enforcement. I've seen there's extensions on ingress and egress to the extent there's inability to access a business for customers or employees. Insurance can cover it. So there may be some solutions there for some businesses based upon their insurance policy. And at first blush, you're not going to see anything about COVID. It's obviously too broad. Or pandemics, but there may be some provisions in there that talking to the insurance agent or talking to an insurance lawyer could provide some needed coverage.
We're up against the time. There was another question that I did want to try and quickly address. It's a great question. It probably requires some follow-up, but I'll see if I can find it. But the question asked about, there was an executive order by the president, I think it was in 2019. Oops, sorry, Ricky, moving that around. Here it is. It's Executive Order 13892, and I'm actually familiar with that. There's a Section 5B referenced in the question. I don't have the executive order with me, but we can follow up and get you an answer on that. But my recollection is that, and you may know, there's been some disagreement between the political parties over the last few years over the strength of executive orders, and more importantly, more pertinent to the question, the impact of guidance. And so, sometimes federal administrative agencies will issue guidance, or officials will issue guidance associated with laws. And the question is, to what extent is that binding? And the executive order that's referenced in the question, I believe, was such that this guidance doesn't have the effect of law and is not enforceable against individuals. And again, I'll clarify after I actually pull the order. And so I think the question is targeted at, how does that impact the analysis that we're talking about today? Can guidance, for example, from the CDC set a standard of care in a lawsuit in Loudoun County, Virginia, on premises liability in light of, in particular, that executive order? And I think the answer is, I think it can. The problem for a property owner defending a premises liability claim is not that there's a federal law that mandates the use of masks. And I think we'd all acknowledge that what the CDC says is guidance. So it doesn't have the force and effect of law, but a standard of care is not is not a law. It's not a state law or federal law. You can have laws and statutes that create a standard of care, but you don't need it. And so the question for a judge or a jury or trier of fact would be, is there a standard of care that governs a particular aspect of the operation of these premises? Use of masks, use of disinfectants, temperature checks, et cetera. And you look to what has become the standard of care in your industry. And, the argument from the plaintiffs will be that with the knowledge of the coronavirus, that, for example, temperature checks, there's guidance from the CDC on temperature checks. We know that temperature is an indicator of infection, or there's at least one indicator of infection, and so that sets a standard of care, and you should check for it. It doesn't mean that the CDC's guidance is law, but courts examining this issue will strive to find what the standard of care is, if there is one. And the CDC guidance or other guidance from governmental bodies, even though it's not a law, will be something that the courts will consider. I think that because there has been so much inconsistent guidance on this, that it's a strong area of defense, and it's frankly some of the rationale behind this effort to provide some tort immunity to business operators, because the argument is it's just fundamentally unfair to tell businesses you can open back up and make sure you stay safe, and the guidance that they're getting is very different. What the mayor of Los Angeles dictates is very different than what say the governor in Florida is doing. So is there a standard of care that's consistent? And I know standards of care are local and jurisdictional specific, but we're dealing with a health issue, and I don't think that there's good evidence of consensus on all of these points yet. But you need to know that there's enough information out there that lawyers have taken the opposite view of me on this, and they're filing lawsuits in the hundreds and in the thousands, and they'll be filing many, many more as businesses open up. So you want to be mindful of the guidance. You want to balance the benefits of opening and the costs of enacting these protections against the risk. And hopefully Congress will do something to provide some immunity. I've exceeded our time here, but we're very grateful that you all took the time to listen to us today. And there's a lot more depth to this topic, obviously. So if we missed any questions, I apologize, and we'll try and get answers to you. And in the meantime, if anybody's got any other questions or specific issues they want to discuss, feel free to shoot an email to anybody, on this panel, and we'll get right back to you.
Yeah, and I just wanted to, again, thank everybody for jumping on, and also to thank John and Rick and Drew for a really informative presentation this afternoon. And as John mentioned, I think we ended up being able to answer all the questions that came in during the program. But if you have follow-up questions, don't hesitate to reach out to anyone on this panel. And just for everyone's benefit, there will be an email going out to all of the attendees of the program today with contact information and also with the materials that we went through. So look out for that in your email inbox. So again, really appreciate everyone jumping on, and again, appreciate our panelists today. So I hope everyone has a good rest of the day. Thanks.